this is Gary Berger on May 1st, 2020. How is everybody doing today? I am doing our weekly Ask a Lawyer video show talking about questions that people have around the law. So with our pandemic and with everybody being at home and quarantining themselves, we thought it'd be a good idea to do an Ask a Lawyer show, ask people's questions, answer people's questions that they ask. And the other thing that we are doing today is we are giving away our Instacart Giveaway. The other way we're trying to give back a little bit to the community is to give a $150 gift certificate away every week on Fridays in order to help people get the staples, get the basic food they need to live this crazy life we're living. It's interesting the way this has affected the law. So typically, as a trial lawyer with a busy practice, we're in court a lot. You go to court appearances to where the judges want to check the status of a case. We call it case status hearings. A lot of times we schedule different things at these hearings. And really with courts being closed, and most courts are closed now, and will be through, the latest I've looked and some court appearances we had next week, the latest orders we've looked is through the end of May or beginning of June. A lot of lawyers that I know are going, why do we do these little hearings where we kind of show up and don't have a lot to report? Now, obviously, courts do have a duty to keep their dockets going. Courts are under mandates to timely dispose of cases, and there's if you're a criminal, you have a right to have a speedy trial and have that resolved quickly for yourself as well. But some of these, it's kind of fun practicing law like this. There's good points about it, and you obviously miss people and miss some of the connections you have with people. One of the questions that I had going in right away already in this case is someone asked me and messaged me. They said they watched my oral argument in front of the Supreme Court, and they asked me, what do you think is going to happen? So I had the opportunity to argue in front of the Missouri Supreme Court about a week or so ago now, and it was a great argument. I really enjoyed it. It was very interesting to do because I was watching this into a camera, kind of like I'm talking to a camera now, rather than doing it live at a podium. So, interestingly though, I'm not allowed to talk about that, and it would be inappropriate to talk about that. So lawyers have a set of ethics that govern our behavior, ethics rules, and they're adopted in every state. And one of those ethics rules, that happens to be Ethics Rule 3.6, says that a lawyer who is participating in the litigation of a matter shall not make a statement outside of the courtroom that they know or reasonably should know will be disseminated in the public and would have a likelihood of prejudicing or affecting the proceeding of the matter. So you'll notice that responsible lawyers, prosecutors, defense lawyers in criminal cases, civil lawyers like me, either on the plaintiff or the defense side, we refrain from commenting outside of the courtroom on this, or we should at least, and lawyers get in trouble when they don't. Sometimes they go overboard and do that. So many times prosecutors will keep their mouth shut and not talk about cases they're prosecuting. Most times defense lawyers would. Now, there are times when they try to try these cases to the press. So the interesting aspect of that, so that's what I'm not going to comment on any case that I have pending in the Supreme Court or any case that I'm going to try next week or anything like that. It'd be unfair. I'd rather let the talking be done in the courtroom, so they say. Now, there are certain times that can be exceptions to that, like if something's in a public record, or you can say that the case is being investigated. You can talk about some of the mechanical things in a case, so like what things have been scheduled. I have a hearing on this date, we have a trial date of this date, that kind of stuff. You can also do things like request evidence or get that kind of information. I have a case now pending in federal court. I won't go into details, where I have done some inquiry through various social media or other places for evidence people may have about what they know about this type of a claim. So we've done that, and a lot of times we investigate that. So you can talk a little bit about a case to, for instance, if you're trying to talk to witnesses in a car accident or that kind of stuff, you can call people and do that. Or you can talk to people, you can get on the news and do that and say, hey, does anybody have any information about who a hit and run driver who may have hit this person? I have a case now, we're just settling it now, where a great guy, he was a highway construction guy, worked highway construction his whole life. He was about to retire. About 2 weeks before he retired, he got hit by a hit and run driver, significantly injured, very terrible, and he's done a great recovery. And I've grown to be very fond of his wife, who's really looks out for him. She sends me these long emails asking all these questions, and she says, "Now, I don't mean to bug you about this, but she's a fierce guardian of her husband, and she's a great client to have. She makes me perform well." But we put out an ad, and there was a big news story on that, and we offered a $10,000 reward along with the union to try to find the driver who did that. So that's the type of trial publicity that you can do. But and this is public right now. This is publicity right now. So I'm not gonna inappropriately talk or try to sway any jurors or sway any decision makers about about that type of a case or any other type of case. People who know me kind of know where I'm coming from anyway on these cases. So my view of these would not have it there. But I have a question here on the feed that I'm looking, and I have a new little gadget. If I swing, got a new gadget, because last week I did this and I had to hold it in my hand. So I have a question about this DOC case, and that was a case I argued. So I do have, and according to the ethics rule, in this case, I represent a class of about 13,000 corrections officers, and so I have a duty to communicate to them about what's happening in the case and events in the case, and that's one of the exceptions that I outlined to you in Ethics Rule 3.6. So what I do is I have a page on our burgerlaw.com website that's maintained by the Orange Design folks, great SEO and great marketing group that helped me with my website. Partners for a long time on that, and we put up, in order to be transparent and to communicate to the class, we put up information about the status of the case. I also send out periodic emails to the class, and when there's something to let them know, and I actually direct them to the website where we say, hey, for instance, we filed a brief, it's on the website. Here's the latest court order. Here's when the trial date is. Here's the other side's brief. Here's a motion we filed. So we are directing them to the documents that are filed. All the documents we're directing them to are public record documents. They have a right to know. I'm their lawyer. So informing them of that information is a way that we communicate to the class. We do it in a public way, because that's our website, but we're not crossing the line or even getting close to crossing the line of any ethics issues, because we do have that duty. So you got to balance those things. I have another question. So those are the things you balance in terms of trial publicity. Now you see people go overboard all the time. You see people tweeting or commenting inappropriately about a case. What about when you see other political figures, not to name anybody in particular, but are literally, there's a General Michael Flynn who's in jail right now. There's talk about him getting retracting his guilty plea, and the president and other people are publicly commenting on that, and the president has commented on other people that have been close to him that have been prosecuted. The president and other people aren't subject to the ethics rules that lawyers are. So you'll see public figures or media people or other people commenting like crazy on legal events, but the lawyers who are involved, who know the confidential information, know all the details and the evidence of the case, they can't comment on it because they are governed by those ethics rules. So anyway, those are some questions that I got when we started this recording about those. Now we're into this recording a little bit. I know some of the people who are interested in the Instacart giveaway are watching also, so, or I hope they are, but anyway. So we have gone through randomly selected. I had my daughter do it this week. Vicki Quentin Bevins. Vicki Quentin Bevins, we have randomly selected you as the recipient of our $150 weekly Instacart cash giveaway. So, not cash, I should say, credit, Instacart credit giveaway. So we will message you, or you can message Burger Law. All we need is your zip code, and we send that to Instacart, and they instantly give you they give you a $150 gift certificate for you to get food delivered straight to your door. And we're happy to assist you and help you out as we help out our other friends, the other friends of our firm. We'll do this again in a week. I know some other people have commented, and I know a lot of people need this and need this help. We're trying to spread this out over time to help as many folks as we can. And Vicki Quentin Bevins, congrats, you're our winner this week. So I'm just going to go through and I kind of talked a little bit about pretrial publicity. I see a lot of my lawyer friends and other people, friends from high school, other folks are watching, which is great. I have a question from Brennan. What about whiplash injuries? This sounds tough to prove if I only feel pain way down the road, no pun intended. So moving on from trial publicity to jump around, so whiplash injuries are interesting. So some people think that with the name like whiplash or something, it's gotten bad press, that people don't really have injuries. Whiplash injury really isn't an injury, that someone who's rear-ended in a car wreck is just going to hold their neck or put on some type of collar and kind of fake it to try to make money. Well, that ain't the case. Whiplash injuries are very, very true. They're very, very painful. Anybody who's had one knows it. And what happens in a whiplash injury is that the person in the vehicle has a sudden deceleration. So if you're going at a certain speed and then your car stops, your body doesn't, inertia, we know Newton's law, you still keep going, you have a sudden deceleration, you go into an airbag, you go into that, and what happens is your neck goes like this, and both in your neck or in your low back is kind of like it's the lever, it's the Archimedes, a lever and fulcrum. If I had a lever long enough and a fulcrum strong enough, I could lift the world. So our necks and our low backs are where where is the pivot point or the fulcrum for our movement, and all the energy gets focused on that area. And in those areas, I don't have a picture with me now, we have these intervertebral discs. I have a lot of videos on the medicine on this. And the intervertebral discs, you have your vertebrae on top of each other, and through the vertebrae go our central nerve and our spine that goes from our head and then innervates our entire body. And so what can happen in a whiplash injury is that in between the discs right there, you get a herniated disc, and the disc material, the jelly in the jelly donut, a disc is like a jelly donut that's like a cushion between vertebrae, and the jelly in the jelly donut breaches. It's called a fissure in the annulus fibrosis, and it impinges, and this is boring medical stuff, but it impinges on the spine, and they do MRIs for this, and that's why people have back surgery, and impinges on the central nerve, and you have pain there. You also have referred pain, numbness. You have pain down your arms. You can't hold things. I have clients who can't hold things, lose complete use of their arms. If you get a herniated disc in your low back, you can have sudden bowel and bladder incontinence. You can have radiating pain down in your legs. They can be severe injuries. Spine surgeons are some of the best, most well-trained medical orthopedic specialists or neurologists we have. It's a huge area of medicine. So whiplash injuries are very significant injuries. They are There can be very well documented. So someone goes without any pain their entire life and then has this traumatic deceleration, a car wreck case, or has it in another way. They fall in a hole, different other ways you can get injured. They can suffer that herniated disc, the impingement on the central nerve, and then they have lifelong pain and symptoms until someone has surgery. And then, you know, what happens is these surgeons go in, they do discograms, they do different studies to figure out what's going on, MRIs, CTs. Then they go in and they take out the disc material and take the pressure, lift the pressure off that central nerve. People wake up from the surgery and this pain they've had for 2 years and the inability to use their leg, the atrophy, they lose muscle in their legs or their arms. All of a sudden it's gone and they're fine. And they get up and they're able to go back and function. And the interesting thing with the surgery is it proves the injury, number one. Number two is you have to remember that, you know, people who are injured have a duty to mitigate their damages. We can't just go sit on a couch and collect checks, right, if you're injured. So you have a duty to get out there. You have a duty to go back to work. You have a duty to go back and do all your medical care. You have a duty to do what you can to get back, to exercises, physical therapy, go to the doctors. And one of the things is you would have the obligation to go have a surgery and get back so you can get back to work so you can minimize or mitigate your damages. So let me keep going here. And CO here, thank you, Scott. Roxanne, I see your messages, Roxanne. Hard for me to get in and figure out exactly what you're asking. So I'm gonna, please give me you emailed me 2 weeks ago. Let me look, Roxanne, at your email again and try to answer your question later today, more specifically to you, Roxanne, but thank you. Hey, Kara, how are you? Good to see you. Good to see you, Jason Stein in DC. I hope you're well, sir. What compensation can I expect if I was in a car accident? Is this dependent on my insurance coverage? So people are calling in and talking about these car accidents, which is great. You know, we do a lot of those. We do a lot of stuff, but we do a lot of those. We try and work on a lot of those. I've been working on those this week and last week for sure. So your compensation you can expect in a car accident. It really is, it's a function of a couple things. One is, like I was just talking about, a herniated disc injury. It depends on your injury, how much of your damage. If you get in a car accident and you're not hurt, you don't have any damages. So then you don't have a claim. And so you shouldn't get much compensation, right? But if you're significantly hurt, then you're entitled to damages for your medical expenses. You're entitled to damages for your pain and suffering. You're entitled to damages for your wage loss damages. You're entitled to any disability or disfigurement you have. If you get medical treatment, but you are gonna be you're not well, you've reached your maximum medical improvement, but you're still going to have injuries and damages, then that's a level of disability too. You're entitled to all these, both past and future. So you may have had pain and suffering in the past, and you may have in the future as well, and you need to recover for that as well. And then, so your damages are what they are, meaning that you may have, your damages may be worth zero. You're not that hurt. Your damages may be worth $50,000 or $100,000, or you may be in a wheelchair and it's hard to quantify, but your damages may be in the millions. And people die, you know, I forget the number, but it's like the fifth leading cause of death in America. So let me get that statistic specifically, but car wrecks and on-the-road injuries and deaths are significant. So people die from these two, and we represent those folks. And those, it's hard to quantify. Those damages are so significant and so big. I'm playing around with my little handy-dandy thing here that's holding my camera. So your damages may be astronomical, but then they're also limited by the amount of insurance, because the minimum in many, if not most states, is $25,000. So what if your damages are $250,000, but you only have $25,000 in insurance to get from the defendant who rear-ended you and had made you have this neck surgery or maybe incapacitated you, you can only get $25,000 from them. So there's a cap on your damages for that. That's so low. Legislatures really should increase that. But you also have something called underinsured motorist coverage. So you may have, although you may only be able to get $25,000 from the person who hit you, you may be able to get more money from your own insurance, underinsured coverage, which is something you pay premiums for. So that way, if you do get hurt by a low insured driver, or you and your family are hurt, that you buy insurance to make sure you cover for that. So that's called underinsured coverage. The other thing is, if the person who hit you or the person who injured you was working for someone, that's a company. You can sue that company or make a claim against that company. So that person may only individually have a low limit of insurance, but if they're driving for FedEx, it's a big company. If they're driving for Amazon or whatever, so though Amazon or FedEx or one of these other big companies ought to have good insurance and do that. In fact, depending on the weight of the vehicle, tractor trailers and other vehicles have requirements, federal requirements and state requirements. Federal requirements to have $750,000 or $1 million in liability coverage, as well as property damage. Let me keep going down, and Roxanne, I don't think I did see your question. Let me get to my next question here. So thanks everybody for watching. Someone asked, any updates on the DOC case? Yes, the new updates are, the new update is that I argued the case to the Missouri Supreme Court on Wednesday, April 22nd, about 9 days ago. Both sides, the appellant, the state of Missouri, the Missouri Department of Corrections briefed their side. We briefed our side. They filed a reply brief, and then I argued the case to the Missouri Supreme Court. You can go on the Missouri Supreme Court website and listen to the arguments. I need to get an update out to everybody on the email list, too, to send you that. You can listen to the arguments. And now we're waiting on the Missouri Supreme Court to make a decision about whether they would affirm, reverse, or take some other action in the case. I really don't want to argue the case here or weigh in on that. I talked in the beginning of this broadcast about the propriety of doing so. I consider it a pending case, so I'll let our well-written brief and my pretty good oral argument, I'd say. I think it was good, but I don't want to be too braggadocious. I'll let those speak for themselves. So you can read the brief at the Missouri Department of Corrections page on the Burger Law website. Go to Burger Law. I think it's one of our drop-down menus. We go to Missouri Department of Corrections, and you can read our briefs, the other side briefs. There's a link to listen to the oral arguments as well. So please tune in there. Would I have a case? Davy Hare asks, would I have a case if a dump truck kicks rock up and cracks my windshield? Yes, you would. I've had a bunch of cases like this. I've had cases with concrete forms coming out of the back of a truck. Had a case with a playground equipment coming off the back of a truck and hitting someone. Both the first one wasn't as bad, but the playground equipment was a traumatic case. It's on the website. It was written up in the papers. We got $2 million in that case for our severely injured client. That was an interesting case because we really had to go to many different insurance policies to stack and find coverage. Coverage on the truck, coverage on the driver, different kinds of coverage, excess coverage to put together at $2 million in coverage. It was I got letters from people when they read about it, about the kind of work we did to find that insurance coverage. It was pretty great success. I'm very proud of that one. It's on the website as one of our successes. It's a few years old now. And yes, you do. So there are very specific regulations, not only federal but state regulations. You have to tie down your load. If you're carrying a load in a truck, you have a duty to tie down your load, whether it's a big thing, a little thing. If there is rock coming out of the back of a truck, you can't let debris and rock come out, because we were talking about inertia at some point earlier in this broadcast. There's a lot of force Now, force equals mass times acceleration. So there's not as much mass in a small rock, but it's still got a lot of acceleration coming off a truck at 70 miles an hour. And if it's a big thing, like, you know, you've seen this before, where someone doesn't tie down a load and it can catch anything. People lose stuff we see it on the roads all the time. But if that hits your car, it hits you, and that can be very, very dangerous, and they absolutely have liability. So what do you do in a situation like that? You try to know who it is. If you're injured and you get hit by something big, you're not going to be able to follow that person and get their license plate. But you have to take care of yourself and the people in your car and be safe right away. You don't want to be so focused on finding out who threw that rock off or that piece of metal off the truck that you injure somebody else. Take care of yourself and be safe. There will be other witnesses many times on the road that'll get that person's license plate and will track them down for you. You don't necessarily have to do that. So be safe, but get their license plate. I've had a lot of times where those people are tracked down. Someone else sees it on the road. Good Samaritans pull that person over, tell them to stop throwing their load around. All right, so I got another question. I'm going to move on. Should you file a medical malpractice claim on your own? So thank you, Rodney. No. You can't. There are times when you may not be able to. There may be times when you do not need a lawyer, but medical malpractice cases are cases where you do. We do a lot of this work. A lot of people come to us asking us to look at these cases. We don't take a lot of the cases that come our way. Frankly, we're very selective. There's a lot of reasons for that. So we're very selective about the cases we take. We only take cases where we think there's a real clear breach of the standard of care, meaning the doctor, the nurse, or the hospital or the medical provider clearly violated the standard of care that they should have provided, and that clearly caused the injury to the person. So the cases are vigorously defended, and the other, so they're tough cases. We're very selective, but one of the main reasons why you can't do that yourself, Rodney, is that Missouri, Illinois, every other state has tort reform, and one of the areas of tort reform that they have is specifically in medical malpractice areas, because those were the areas when tort reform goes in waves, and the main waves where it's been enacted is when doctors, who everybody loves doctors, we all trust our doctors, they're on the front lines right now battling COVID, they're heroes, no question. But those folks have lobbied hard, and the insurance companies to insure them more have lobbied hard and gotten tort reform. So, for instance, you can't just file a medical malpractice case. You have to have an affidavit from a doctor in the similar medical practice who says that they breached the standard of care, they were negligent, and that caused the injury or death to the person. You have time limits to do that, otherwise your case is going to get thrown out. The affidavit has to be in a very specific form as well. That has to be done. It has to be either filed with the suit or within 90 days of the suit. It's called an affidavit of merit or letter of merit. There's also limitations on the amount of non-economic damages you can get. There's limitations on venue rules. There's a lot of different limitations in medical malpractice cases. So if you have a medical malpractice question, fill out a contact form on our website or call us on our phone numbers. We're happy to do that. We get a lot of calls on medical malpractice cases. We do take them, but we're very selective. But we'll analyze your case for you and tell you whether the case has legs and we think we can win it in trial, or whether or not we don't think we can, and we'll let you know the reason why. I see another. I'm just scrolling down. I see another question. What's an affidavit, and do I do that? Affidavits are in state court. Declarations in federal court are used to put evidence before the court. So sometimes, to place more non-contested evidence in front of the court, you can do an affidavit where the affiant swears that what they're going to say is true, and they say certain things. So in a non-contested matter, a person can fill out an affidavit, sign it, and then it's usually sworn to by a notary public, and then that can be put before the court. So now it can be contested things too. For instance, you do those when you file summary judgment motions, you put additional facts before the court. So it's a way to put evidence and testimony in front of the court directly. Sometimes affidavits are used to get in business records and other things where it's less controversial. So my friend Aaron Wilson asked me, when car 1 hits car 2 and car 2 hits you, do you go after just car 1 or car 1 and car 2 insurance? Or usually, Aaron, in a nutshell, usually you'd go after just car 1. You're assuming that when I answer that question because you say when car 1 hits car 2. That, to me, that you're reading in that car 2 is the at-fault driver. So again, it kind of depends. But if for instance, if you're stopped in traffic on 270 or 40 or 44 or wherever you are, 55 south, when it gets jammed up, and you're stopped and there's a car behind you safely stops, then some other guy is on their phone watching this video. Don't watch this video if you're driving. Some other person, and can someone please cut my hair? Lord, I've been home for so long without a haircut. So that person, when that driver who's watching their Facebook or not paying attention, rear ends a car, then rear ends you go after the negligent drivers, whoever's liable. Now sometimes that can be hard to figure out. I've had other cases where under different circumstances where you do go after both. We have a case right now where we resolved the underlying case and we're suing on the underinsured, where what if there's 2 impacts? What if the car 2 hits you and then car 1 hits you? What if you have 2 impacts? So what if you stopped safely and both people behind you weren't paying attention? How do you parse out those damages? What if you're hit by one person and you go to the side, or one person hits you and then goes another lane, and hits another car. So there can be other circumstances. What if there's, and we have the case now where we're suing the underinsured. It was weird, strange, because there was one impact to our client, but one car had switched lanes right before the impact. So one car switched lanes into another car's path. The other car behind him said, hey, I would have been able to slow down and stop in time, but this other guy switched right away. It happened to be a guy. And that impact all happened at once. So there can be a lot of different circumstances. I hate to just answer it one way, but we certainly look into that, and you look at the police to figure that out. You also look at the police report. You call witnesses. You talk to the people on the ground, and try to sort out who's the liable party. Who do you think, in fairness to the jury, what they're going to say? So, what they're going to decide, rather. So, you want to be careful not to be too much of an advocate and have your blinders on or have tunnel vision and only focus on one thing. You got to pull your head up, look around, and make sure you have an accurate assessment of who the liable parties might be. Excuse me with my camera there. Brennan, my friend Brennan, what's the weirdest general damage you've seen? Loss of enjoyment, and others seem pretty vague. How do you calculate these? I had a client one time, and I was in his deposition, and he had tattoos everywhere and multiple piercings in his nose and in his lip. He's kind of a friend. He called me within the last month, but I won't say his name. We're in this deposition, And he says, and so remember earlier today when I was talking about whiplash and back pain and stuff, one of the ways you can treat that is through injections. And what the injections do is they go in and they put a inflammatory in there, like a lidocaine, and then they put some type of a steroid or put a anti-inflammatory back in there, and it decreases the swelling of those tissues, takes the relief, the pressure off the central spine, so then you have relief of your symptoms. I have one great lady, she's a dental assistant. We just settled her case where she would get, and so she's in a chair hunched over all the time. She had a bad wreck. She gets one of these injections a year. She's fine. She doesn't want surgery. She's never going to have surgery, but she does need to have one of these injections every year. Anyway, he stopped getting injections. And they asked Billy, I said his name. They asked Billy, they said, why'd you stop? You're in so much pain. Why'd you stop getting injections? And he goes, he looked him straight in the eye and said, I'm afraid of needles, with all these piercings in his face. And I just started laughing. Weirdest general damage I've seen, it's hard to say weird, everybody's different. So somebody may, it's, and we live in a cold, hard society, or we did before this COVID. Maybe this pandemic is going to make us kind of feel for each other a little bit more. But one person's terrible, terrible injury that they can't do, other people can laugh at it or minimize it, but to that person, it's a big deal, I have women who, mostly women, when they have back or neck injuries or arm injuries, they talk about not being able to hold their kids or hold their grandkids, and I get a lot of defense lawyers on the other side in those types of claims kind of poo-pooing that and saying that's not a big deal, but to them that's a big deal. I was joking about my hair. My hair may be a little bit blah because I jumped in a pool for the first time this year with my little almost 2-year-old son, and that is the biggest joy there is picking up your kid and playing with your kid if you're a parent. But I don't really have any other weirdest general damage question. I'd have to think about that a little bit more. I mean, I can tell you one. So here's another one. So I had a client on the stand, and he's a truck driver, and I tried this case against a good old lawyer. I've tried a bunch of cases against him. He's retired now, but my client wanted to make a wage loss claim. He was a truck driver, and I tried to say no, and I said no, but he's the decision maker, right? So we make this wage loss claim, and the net wages he's claiming is about $30,000. However, but they put in his tax return, his income, he brought in $500,000, $500,000, and then with fuel and taxes and all this other stuff, he only paid taxes on $30,000. So they didn't cross-examine him on, and pigs eat and hogs get slaughtered, and if you try to, juries are smart. They figure this stuff out. If you try to overreach and damage, it kills your case, and you should never do that. I won't do that. I'm giving you one example. On that one, I think I was willing to do that one because the truth is, if you're your own truck driver, and any of the truck drivers out there know, you can, on the paper, it may look like you're bringing a lot of money in, but if you have to pay your own fuel, your own insurance, all these other things, what you put in your pocket, what you actually take home is a lot less. But anyway, he looked terrible in front of the jury, honestly, on this one. It was just, the cross-examination was, no, wait a minute, look up here, your gross income was $500,000 and you're only paying taxes on $30,000, and that just doesn't pass a smell test. You can try to explain that away, but that's just never going to get explained away that well. Well, folks, I appreciate everybody listening to me or watching this today. We try to do these. That's water. That is not beer. So we try to do these Ask a Lawyer. Do you like my sign back here? I'm going to show you my sign. I hope it's not backwards. It may be backwards. It's backwards to me right now. Be epic. Be epic. My wife and my kids painted that for me before I had this Supreme Court argument last week, which for me was a big deal because I represent some amazing people that need to get some justice. And we're going to keep fighting until we do, always. So tune in again next Friday at 4 o'clock. We're going to have more questions and more Ask a Lawyer questions. We're going to give another Instacart giveaway out. I always try to answer questions for free to all people who call and all the folks who reach out to us. We take the cases that we can and get justice for those who we can. And but we'll always answer your questions for free. That's been a commitment that my firm has made for years and years. Everybody have a great weekend. Happy May. Hey, I should have led with this. Brennan or somebody, you should have told me this. Today is Law Day. May 1st is May Day. It's Law Day. It's a lot of other days. So happy May. Happy spring. Everybody be safe out there.